So thanks everyone for joining. I think we have people dialing in from here in the US, from Europe, and from China. So good morning, good evening, good afternoon. Today we'll be discussing what I think is very interesting and timely topic on doing investigations and due diligence projects in China. My name is FeiFei Zhen. I am counsel at Miller Chevalier. I'm duly trained in the US and China and focus my practice on government and internal investigations and corporate compliance matters, especially those involving China, which I've done a ton of work, and relating to anti-corruption, anti-money laundering sanctions, and trade controls. Joining me today are Patience Bing and Tim Stanley. I'll turn to Patience and Tim to introduce themselves.
Thanks, FeiFei. Hi, my name is Patience Bing. So I'm currently a senior director in the Global Compliance Department of Zoetis. Zoetis is the largest animal healthcare company in the world. So currently I'm managing the Global Anti-Corruption Program, Conflicts of Interest Program, and also the AI Governance Program for Zoetis. I'm also managing the enterprise-wide human rights due diligence program for the company as well. And before I joined Zoetis, I was working in Singapore, Washington, D.C., and Hong Kong in regional in-house roles, running compliance program in Asia Pacific and China. And also I had global law firm roles before, as well, spending significant time advising global companies operating in China and also conducting internal investigation in China. I have been in the field for 15 years.
Thank you, FeiFei. Thank you, Patience. My name is Tim Stanley. I'm a director at Risk Advisory Group. Risk Advisory Group is a global business intelligence firm headquartered in London with over a quarter of a century track record. We conduct due diligence and investigations on behalf of our clients. I'm currently based in Zurich, but previously was based in Hong Kong and was responsible for our Asia business. So that was overseeing operations and investigations out of our Hong Kong and Singapore offices. And I continue to work with clients in the region.
Awesome. So today we will dive into each of these issues more later on, but this is an overview of hot topics, key issues that we're seeing or expect to see more in the context of investigations and more so in the due diligence space. Obviously, this is the Anti-Corruption Committee. Anti-corruption remains to be a key issue and hot topic in China, not just FCPA enforcement. In China, in the past few years, there has been a crackdown on corruption in the healthcare industry, also anti-competitive conduct and revised regulations in this space. We'll discuss more. Supply chain obviously has been under scrutiny for the past couple of years, increasing enforcement and due diligence burden. Otherwise, there are sanctions issues involving China, usually secondary sanctions for supporting actors in Russia, Iran, or North Korea. We've done investigations in that space as well. And the others are, some are new regulatory framework, like the outbound investment regulations, information communication technology and services regulations, and bulk data regulations. These are three different new regulatory frameworks that impose additional due diligence requires for certain transactions involving China. And the final bucket is the common issues, internal investigations that are not government facing, but we see a lot of fraud, conflict of interest investigations and issues, and thefts of properties, whether it's physical or IP. So these are the issues we see, and we would discuss more. Now, on the anti-corruption piece, from the US, maybe many of the audience members know over a year ago, US signed into law the first statute that directly criminalizes the request or receipt of bribes by a foreign official. But after a year, I think it remains to be seen how this law would be enforced, as well as the future enforcement of FCPA. But on the China side, there have been a few more developments. One is the revised anti-corruption law. So this was revised around the same time when FeiFei was passed, and its provisions within the Chinese criminal law. So now it criminalizes private company individuals, officials, managers to abuse their official positions or sell company assets for illegal gains. So these that type of behavior, common themes in investigations involving Chinese third parties or Chinese subsidiaries of a U.S. company. So I think the new law can serve as an effective deterrence to managers in the Chinese operations that, they don't have to, they have to worry. It's not just the laws from far away land in the US, like FCPA or FIPA, that they could also face real criminal consequences at home. The anti-corruption law now also specifies high-risk industries such as finance, healthcare, education, and it imposes heavier penalties. The anti-unfair competition law was just revised in December 2024. Now it specifically prohibits using bribes for gaining business opportunities or advantages in China. And this law, before the revision, it has always been understood to prohibit that type of behavior, that's anti-competitive behavior. But now it spells out in the revised law with specific prohibition and imposes penalties on bribe receivers and also legal representatives and other individuals responsible for commercial briberies in the corporation settings. And the last piece is specific to the healthcare industry, where just last month, the Chinese State Administration for Market Regulation issued a kind of first ever compliance guidance for pharmaceutical companies. It has general principles, talks about how to establish an effective compliance program in the healthcare industry, and what are some of the elevated corruption risks, such as hospitality, discounts, rebates on clinical research, outsourcing speakers' fees, all the common themes we have seen in FCPA enforcement as well. And I want to turn to patients who has had some experience dealing with Chinese government-initiated antitrust investigations, and obviously, as an animal healthcare company, some of the compliance issues that you have experienced with in China.
Oh, thanks, FeiFei. So I'm speaking in my general experience in terms of when in my private practice areas and also later in in-house experiences in terms of dealing with government-initiated investigations. So in general, in China, if there is a government-initiated investigations, in general, like anti-corruption, can be done under the legal framework of anti-unfair competition law. Because the SAMR, which is the State Administration of Market Regulation, might consider that the providing of certain expensive gifts, hospitalities, or even like medical equipment to hospitals as anti-competitive behavior. So therefore, as FeiFei was mentioning, the guidelines on the compliance program for the pharmaceutical companies, we do need to, when we are sitting in a global role in implementing a global compliance program, we do need to make sure that we do have a tailored compliance program for China as well. In the context of a pharmaceutical company, we should always have local policies in China, adjusting a specific thresholds and pre-approval requirements in terms of like gifts, hospitality, or grants, donations, and anything of value that we are providing to healthcare professionals.
Thanks, Patience. Before we get to the supply chain piece, I forgot to mention, if anyone has any questions, please feel free to put your questions in the comment chat box. We're monitoring that, and we will answer as we go, and also at the end of the session. So Patience, do you want to walk us through some of the regulations impacting supply chain and due diligence and compliance?
Yeah, sure. So anti-corruption is a topic that is very commonly discussed together with human rights. I mean, obviously, in countries with a high risk of corruption, they may potentially also have a high risk of human rights violation as well. So in many companies, they combine both approaches together, and some companies want to separate them. Just in terms of an overview of the ESG laws in recent years, as you can see from the slide here, in recent years, there have been like global trends in developed countries in terms of ESG laws. Even the current US administration continues to enforce UFLPA very rigorously, and recently adding 37 Chinese companies to the UFLPA entity list. Outside of the US, there is also no slowing down in ESG laws, and they cover all geographies in addition to China. Some may require due diligence, some require disclosures and training, or all of them. Like for example, the EU CSDDD, they require companies to identify and prevent human rights abuses within their supply chains. So from a more strategic perspective, as an in-house counsel, really based on your industry, you should really use a risk-based approach and prioritize the high-risk countries, not just China, but all high-risk countries for potential human rights violations. High-risk material categories, like, for example, like cotton, and high-risk spending suppliers. And also, in addition to that, documentation is very important. You need to keep a clear record of your due diligence efforts, because you may be required to disclose them, to demonstrate compliance with the law as well.
Thanks, Patience. The next, I want to cover on a very high level some of the new regulatory frameworks I mentioned earlier. And these are just either final existing regulations or proposed regulations that really impose additional due diligence requirements on parties doing transactions or business that involve China. So the first one is outbound investment. It's like what's people often call the reverse CFIUS. Basically, if you're investing from the US into certain industries in China, then there are certain transactions that are prohibited or requires notification to the Treasury, and it imposes a knowledge requirement on the US person making the investment, which would require enhanced due diligence for conducting transactions involving China and other compliance efforts such as record-keeping obligations, reps and warranties, monitoring, and all that good stuff. The second framework is in the information communication technology and services space, the ICTS. There are two regulations. One actually took effect, I think 2 days ago on February 4th. It establishes procedures for reviewing transactions involving certain ICTS that are essential for autonomous systems, advanced robotics, or AI and machine learning. And the other piece is a proposed rule on connected vehicles that would prohibit sales or import of connected vehicles that has certain specific hardware and software that have sufficient nexus to China. And the regulation focuses on hardware and software integrated into like a vehicle connectivity systems or software that's integrated into automated driving systems. And the idea is the US government doesn't want China-made cars with these advanced capabilities to be running around the roads here that can enable them to collect certain data and information. And this would require importers and manufacturers of those vehicles to gather information and documentations from their suppliers of components and softwares to verify their compliance and provide evidence to the government of their due diligence efforts if needed. And the third new framework is the bulk data regulation. Again, this is a proposed rule that's not final yet. It's a DOJ regulation that prohibits certain commercial transactions between US and several countries of concerns, including China. And it would affect certain like vendor agreements, employment agreements, non-passing investment agreements. So again, these regulations would require US persons to conduct adequate due diligence as a part of the risk-based compliance program that Patience was just discussing. And obviously, sanctions and export controls in the past few years, a lot of rules on semiconductors in the AI space, advanced computing. It remains, there are so many rules, mostly a final, some are proposed. It remains to be seen how the new administration would deal with some of the proposed rules, even in the biotech industry and AI diffusion. Lots happening right now. On the sanctions front, I just want to mention one thing. In addition to the secondary sanctions type of investigations that we do, the 2024 National Defense Authorization Act prohibits DoD from procuring goods, services, technology that are produced or developed by entities identified as Chinese military companies. So these prohibitions are going to take effect in 2026 and 2027. But again, if you're a government contractor, this now there are more due diligence requirements for you to know your suppliers. And going to the other side, so now we have all these US and European and other regulations imposing a lot of due diligence requirements, but on the other side of the equation, some of these new laws, some of these laws are not news, but definitely there are increasing complexities and uncertainties for doing investigations and due diligence in China. The first top three ones are the key ones. Obviously, state secrets law is aimed to enhance the protection of Chinese national security and interest, including the protection of sensitive data. And the revised law from last year now explicitly allows Chinese authorities to, as part of their investigations, to review materials, interview personnel in China, record whatever information they consider as relevant, and keep in their possession relevant facilities, equipment, and documents. I mean, technically, I think the Chinese government has always been able to do that, but this is now basically codified in the statute. It also has this undefined term of work secrets that would be a new category of protected data, which hasn't been defined. The anti-espionage law was revised about 2 years ago and added stealing, spying, purchasing, or illegally providing certain data, documents, materials, and items related to national security as potentially espionage acts. And there has been raids and enforcement against different foreign companies, including consulting firms, as part of the targeting foreign business that provide sensitive economic data or access to experts in different fields. And Tim would discuss a little bit later how these developments are impacting his industry and their operations. Anti-foreign sanctions law, this is not new. It's been almost 4 years since it was passed. It allows Chinese government and private parties to respond to, quote, discriminatory restrictive measures against Chinese organizations or Chinese citizens, or otherwise interferes with Chinese internal affairs. And the potential countermeasures could be travel-related visa, cancellation of visa, no visa, barring anyone from leaving the country, seizing properties, or prohibiting certain organizations or individuals in China from doing certain businesses. But for a long time, for a couple of years, this law wasn't really enforced, and then the enforcement was largely symbolic. But last year, I think maybe around the fall, China initiated the very first investigation under AFS, under this law, into PVH, which is a U.S. fashion retailer and owner of Calvin Klein, for their alleged refusal to source cotton from the Xinjiang region. And there's not much public information on that investigation, but it is a first substantial step taken under this law that wasn't taken before. And I just want to briefly mention a series of data regulations in China that were implemented over the last 4 or 5 years. All of these data laws and implementing regulations are really making it more complex and challenging to do investigations, especially, and not just doing investigations, but also just on how you can store and use data in China. And if you ever need to transfer data located in China out of China, what you can do and how you do it, it's definitely getting more and more complex. And here are some other AI-related new measures which patients would discuss later. But now will come to talk about, so that those are the regulatory updates that I think are very relevant to doing investigations and due diligence in China. But now we're going to actually discuss what is the current operating environment in China, what can people do and think about when they take on these type of projects. So I want to turn to Tim. I understand that you guys have closed your office in Hong Kong after being there for a very long time. And we also know a lot of law firms have also exited China or the broader China region. So can you tell us a little bit more about the decision by the risk advisory group to leave Hong Kong and just the broader environment?
Thank you, FeiFei. Yes, happy to. So we took the decision. It was not an easy decision to reach, but it was based on the national security law, which the first version of which was introduced in Hong Kong in 2022. As you mentioned before, the lack of clarity over what constitutes work data or work secrets, issues around treason and national security, and the extraterritoriality of some of those provisions really gave us pause for thought. And as you say, we're not alone in this. The Economist last month, I think, had a statistic saying that there were 35 top-tier American law firms still operating in mainland China at the end of 2023. Of the top law firms that were operating there, by a year later, the end of 2024, 35 of them had either reduced their presence or shut up shop entirely. And I think that will be to a large degree in response to a lot of this new legislation that's been coming in. And those that have remained, as we know, there's been public media about this, have had to sort of isolate their China operations from the rest of the business. So there's definite challenges there. There's an article today, just today in McKinsey, about McKinsey from Bloomberg, and they are going through this decision-making process at the moment, trying to decide whether they should remain in the mainland. That quotes an American Chamber of Commerce and China publication from January, a survey that they conducted of their members, in which 30% confirmed that they were considering moving operations out of the country or had already done so. So I think it's, every company has to assess its own risk tolerance based on its own activities for itself. There's clearly a long list of contentious issues between China and the West, and I think it would be naive to believe that might go away anytime soon, no matter who sits in the positions of power. I think the good news is that despite leaving mainland China, we can continue to do really sort of high value added due diligence and investigative work for our clients. And in some cases, not having a footprint in the mainland can be an advantage, in fact, because you need to be less concerned about some of what we might have been concerned about before. I think what we're seeing are two overall trends which happen to be going in different directions. So political economists use this term degree of openness, and it analyzes the extent to which a country is trading externally. China, by one measure, peaked in 2006 in terms of economic openness, and it's been downhill ever since. So that's one trend, and I think we're unlikely to see any dramatic shifts there in the short term. The countervailing trend is actually in openness to visit the mainland. Visa liberalization is in full swing. It's never been easier for most Westerners to visit China. You can either get a sort of visa on demand, or you can completely do away with it for a period of time if you're entering one airport and getting out of another. So that has a sort of purely economic objective in trying to increase the number of visitors, for overseas visitors to China. Before the pandemic, I think 2019, there were 60 million, which is still, a relatively small number for a country like China. But last year there were 30 million. So, you can understand why the authorities there are very keen to increase that. So two overlapping and trends sort of going slightly different directions there, I'd say. I think it's important here to talk about red lines. We used to talk about the 3 Ts, Tibet, Tiananmen, and Taiwan, as being issues that were particularly of particular sensitivity to the Chinese authorities. I think most analysts would agree that that number of issues of contention has actually increased significantly. So that has an impact on people like us when we're conducting due diligence or doing investigations. It may be that we would be reluctant. And every case we make an assessment on a case-by-case basis, but some typical other sort of red lines might be around senior level CCP members and their families, the military or defense or dual use technology, however it may be defined, whether there's ongoing investigations by the authorities, anti-corruption investigations, as is the case, for example, right now with healthcare. Hong Kong obviously has been a bone of contention for the last few years, and Xinjiang and the exports of sort of cotton and other products there in relation to concerns over forced labor. So it's an ever expanding list of issues to be concerned about. And I think that's something that you'd see as well, FeiFei, from the legal perspective, right?
Yeah, yes, for sure. And I definitely agree with the case-by-case analysis, sometimes in a specific project, stage by stage, to see if the risks have changed. And given and the geopolitical relationship of the day now, that there are a lot of uncertainties. And I think this is a good point to answer. We have 2 questions, and on the red lines, I think those 2 questions are relevant to what Tim, you and I are discussing just now. So the first question is, I work for a voluntary international standard working on engagement with Chinese companies. What regulations might enable or prohibit Chinese companies from engaging in a third-party audit, whether operating in China or outside China? So I think third-party audits, we do that routinely. I'm sure Tim, like Patience, you guys probably have experience as well. It's not a big issue unless the audit may get close to the red lines, that the sensitive topics and data that may be involved. So you would have to look at the scope of the audits, what is the subject, what is the information you're trying to get for the audit, and what kind of audit steps you're taking. Do you need to do on the ground interviews and talking to people and gather information? It's still okay to do it, but if it's certain industries or certain topics, then it could be very high risk. There are areas I would definitely say you don't want to be on the ground to do third-party audits, but otherwise, I think in most industries, for most standard third-party audits that we do, it's still fine. And on the regulations piece, it's the same regulations we discussed before. Like if it's a sensitive topic, it's high technology industries, supply chain related matters, and sanctions, export controls related issues, you want to consider whether the anti-foreign sanctions, whatever you're doing, would that be considered as discriminatory measures aimed at Chinese companies? And on data, how do you manage the data you collect as part of the audit, and what to do? Those are all relevant regulations. And the second question is, can you speak to the concerns that the kinds of end user ultimate consignee information that will be need to be obtained for compliance with US sanctions and export controls that could conflict with US rules regarding sensitive or confidential information. So this kind of along the same lines, the last question is where the red lines are. It's not impossible. It's actually pretty routine to do end use verifications involving China. And in fact, I think BIS has mentioned they did over 100 end user verifications involving China over the last couple of years. And they have people, like they have their office in Hong Kong. So it's possible to do it. And as part of and it depends. There are companies that are that may be they might be just doing completely innocent and transactions that are not violating any U.S. sanctions or export controls laws. But and in that case, they want to do business overseas, and Chinese government wants Chinese companies to continue doing business overseas and succeed in those businesses. So providing information, end use and user information that are not jeopardizing crossing the red lines or getting close to the red lines are fine. But then also depends on how you ask those questions, because you don't want to put people in China, they want to help providing the information you need to facilitate whatever business dealings that you have. But they also worry about consequences that they may face if the information being requested relates to sensitive topics. So it's kind of an art to see how you ask those questions to make them feel comfortable to provide information as part of the business operations, not as a part of efforts to be compliance with U.S. laws, even though getting the business information is part of the compliance of U.S. laws. I don't know if that answers the questions. Feel free to type in more questions if you have follow-ups. I'll turn back to Tim to discuss the information availability in China.
Sure. Thank you, FeiFei. So I think one of the big changes it has been in accessibility of available information when we're conducting our investigations. It doesn't only relate to China. This is a trend I think that we're seeing in a lot of other different jurisdictions. But typically, when we're doing our open source research, we'd be looking at a range of different sources, from government provider to third-party aggregators to litigation databases. Whereas 4 or 5 years ago, it was possible to access that information from outside the mainland. Now that's no longer possible. So in order to access on various different databases, you typically have to have a mainland phone number to input, or you need to use a mainland Chinese ID. So that obviously potentially limits what is possible, what information is possible to access from outside the country. It also, of course, provides an auditable footprint of who has accessed what information. So from a Chinese authorities' national security point of view, they can basically see who has been looking at what. That's obviously of a consideration for investigators. So that's one area I'd say which has become slightly more challenging, but not insurmountable. The other area is when we're talking to knowledgeable sources on the ground. And again, I think this refers back to the sort of red lines we were talking about. Sometimes we may have an investigation subject that we consider maybe particularly sensitive, and we ask our local sources and they say, no, actually that's fine, we should be able to make inquiries about this individual or this company or about this issue. Other times it's the other way around. So we just do need to, I think, always be aware that the people who face the consequences of anything going wrong are the people who are on the ground, and we need to take our lead from them. They have they're best able to assess the risks of making these sort of inquiries on sensitive subjects. And then I think finally, a sort of good risk mitigation tool, if you like, is creating, if you don't already have sort of China project acceptance policies. And this can be twofold. And again, it's something we ran when we were sitting in Hong Kong. So there was one set of risks which relate to the clients themselves. We always had a limited number of Chinese clients, but nevertheless, it's a good discipline to go through, and it applies equally to clients from other high-risk jurisdictions. So going through that client acceptance policy, and then equally there's the project acceptance policy. Sometimes, an overseas client may ask us to conduct research or be conducting an investigation about subjects which may be particularly sensitive from a China perspective. And that could involve state-owned enterprises. It could involve, as I mentioned before, ongoing law enforcement or sort of political investigations, some of the red lines we talked before. It could also involve the objective of the investigation. What is the purpose of this? What's the information going to be used for? And could it be interpreted or misinterpreted potentially as being an exercise that could be hostile to the interests, for example, of the Chinese state? So again, it's something that's very important to consider at the outset of any project. There are lots of different ways you can mitigate some of these project risks. Ranging from not having a footprint or not engaging local staff. It may be that you want to conduct open research only and do that from outside China or Asia, and the project could be managed in such a way that there's no local touch point. It might be that you conduct the investigation via outside counsel, and I'm sure FeiFei and team have a long list of very strong Chinese law firm partners that they work with on a regular basis. And then there are also communication protocols and data security protocols, which are fairly standard for lots of different jurisdictions. So I think these are some of the ways that we've seen over the last, say, 5 years. We've seen how we handle Chinese investigations shift. It's become a little bit more challenging, but it's certainly not insurmountable. And as I say, we can still continue to do a lot of the work that we did even when we had a footprint there.
Thanks, Tim. And now I'll turn to Patience to discuss from her in-house perspective how companies are managing their compliance programs and responding to these developments.
Oh, thanks, FeiFei. So if you are sitting in a global role and trying to implement a global compliance program, including China, like myself now, I'm sitting in New York and trying to implement a global compliance program and address, different risks from different areas of law and also in different countries. I highly recommend, because of my also local and regional experience in China, I would highly recommend you tailor your compliance program for China, and here's why. So first of all, as you know, China is the world's second largest economy with its own distinct language and culture. As FeiFei and Tim was mentioning, China has a very, very complicated legal environment from both Chinese and Western perspective. And also even from an internet restrictions perspective, like the inability to access Gmail or Google or basically any international website. And you have to use Chinese local apps to basically access anything you can access in China. And also on top of that, the monitoring and censorship of online activities really requires a different compliance approach. So even when I was working in Singapore and managing a compliance program for Asia Pacific, I can clearly tell that the compliance approach we are using for China is very different than the compliance approach we use for countries that is not China. So what I would highly recommend is, first of all, from a resource perspective, you hire, if your company, if it makes business sense for your company, I would highly recommend hire a dedicated compliance resource in China to not only serve as your eyes and ears, but also an advisor in the market. Or if it doesn't make business sense for your company, at a minimum, have someone sitting in Singapore or Hong Kong in an Asia Pacific role that is familiar with the China operations. So in addition to that, I was mentioning about tailoring policies for China. I think I briefly mentioned about anti-corruption. I think even from an AI perspective, I don't know if the team has follow up on AI regulations. So globally, we have a lot of AI regulation right now from the global landscape. And the majority of the AI regulations outside of China, like the EU AI Act, mainly focusing on things like biases, fairness. But the Chinese AI regulations are very unique. I mean, they're focusing on consumer protection and also the censorship of content. So if, like, for example, your Chinese operations want to leverage AI to improve their productivity, I would highly recommend they just work with local large language models or any AI providers and try to develop this locally rather than trying to source the technology from outside of China. Not only from a compliance with the Chinese law perspective, but also from a practical perspective. You want something that the content that is complying with the law and also fits the Chinese language and and the market. And finally, in terms of investigations, I mean, in the unfortunate event, I mean, if your company, receive a down rate, by the Chinese authority, it's very important, to partner with a reputable US law firm like Mueller and Chevalier, so that you have credibility in front of the audit committee. But in addition to that, it's also extremely important to partner with a trustworthy Chinese law firm under the supervision of the reputable US firm. As you may know, only Chinese law firm can legally interact with the Chinese authorities to represent the company. And the Chinese law firm should also be a firm that really knows what is going on in the market. I mean, the Chinese authority investigation can go under different levels, municipality, provincial level, or national level. You want the Chinese law firm to really know what is going on so that they can help you negotiate with the authorities. Sometimes the authorities, in addition to wanting you to improve the compliance program, they may also say something like, oh, you may need to increase your investment in the particular market so that they can generate more tax revenue, which, in the Western world is pretty unusual as part of the settlement. But that would be something that really your Chinese law firm can guide you. And I think, FeiFei, you also have some perspective about that.
Yeah, for sure. And the Chinese, we work with Chinese law firms all the time, whether it's full service national firms or more regional smaller firms where attorneys may have worked as prosecutors before and have information that's localized and necessary for specific investigations and enforcement. And in addition to, I guess, government-facing investigations in China, we rely heavily on local counsel in doing internal investigations as well as due diligence projects as well, because of the complexity of the Chinese regulations I discussed earlier, and they can help you devise all the nuances of those regulations and how data can be collected, used, and potentially transferred or not transferred out of China. And so we're moving on to the last piece. We want to share some of our perspectives and takeaways and recommendations that have helped us. Some might be stating the obvious, but they're so important to keep in mind, especially in the current climate. As Tim discussed earlier, it's definitely more challenging and tricky to do investigations and due diligence in China compared to like 5-6 years ago. But it can definitely still be done successfully where proper frameworks were put in place for doing those type of projects. And when risk assessments are properly conducted. And the key we've mentioned a few times is to know what the red lines are, where they are, and the nuances in factors that need to be considered for each project from both sides, the under US regulations and under Chinese regulations, and figure out a tailored approach to each project, especially when the project might involve sensitive topics and industries such as high tech, supply chain related issues. Having said that, though, yes, these are sensitive issues that should be given more considerations and caution. But I've also seen, an increased tolerance by companies and law firms in China in dealing with some of these sensitive issues. So for instance, if you ask a Chinese law firm 2 years ago to help with an UFLPA project, the likely answer would be no, that is where the red lines are. But nowadays, there are definitely increased tolerance by Chinese companies and law firms in responding to some of the supply chain audits or inquiries, document requests. It's because with all the regulations, not just in the US and all the EU, Australian regulations patients discussed earlier, is a global trend to have more transparency and visibility into supply chains. And Chinese companies, they want to do business successfully outside China. They don't want their goods to be detained before entering a country. So in that sense, this is the effort to help in some way comply with those regulations so that business can be done per usual. And the key, as Tim mentioned, is to work closely with your local team and local counsel whenever it's needed to collaboratively assess the risks and determine the approach for each project. And it's important to trust their judgment and experience. I would say be transparent, but with caution. So you don't want to be transparent, dump all the information on the local folks that could put them in a difficult position or trigger countermeasures such as those available under the anti-foreign sanctions law. But I also think you cannot carry out a project or an investigation in the most effective and efficient way without sharing key information. So above all, you don't want to withhold any information that could potentially put people on the ground safety in jeopardy. And the second point is to stay on top of all the regulations and news and developments that may be relevant to your businesses and related requirements, such as additional DD expectations, and to proactively putting in place a plan to respond to those developments and taking into considerations of not just the requirements of like US regulations, but also potential implications in China. I know patients, you mentioned down rate before in the compliance program. I don't know if you want to add a little bit more perspective here.
Oh, yeah. So, yeah, I mean, if your company does not have one already, you should definitely have a down rate policy for all your global offices, I mean, including China. In the context of China, because of the potential, likelihood of a down rate, I would highly recommend that you make the down rate policy as clear as enough in terms of who the front desk or whoever that is receiving the officials that are visiting the office, like who the front desk should contact and who the local counsel should be involved in the event of a down rate. And as you may know, I mean, in China, there is no attorney-client privilege. So in that case, how do you deal with all these like sensitivity information and the collection of the sensitivity information by the authority is very important. So you definitely need a specialized down rate policy for China, and also make sure the employees are being trained on that as well, especially the front desk and security employees.
Thanks, Patience. And so I guess the first three bullets are like on a higher level, bigger picture thoughts and recommendations, and then we go to a little bit on a granular level for travel. Like for instance, in the past 2 years, I get questions all the time from both people in China and people here talking about whether it's okay to travel to the other side. And so we want to discuss that a little bit more. Tim, do you want to talk about like laptop policies that you have seen? And we have that type of policy as well.
I'm sure most organizations do, FeiFei, and actually most organizations will also have travel security policies, whereby, I imagine China will be deemed a high-risk environment, and therefore that will require a certain sort of escalatory approval system. So don't, one thing I would say is don't try and go around that. That's there for a reason. If anything happens to you while you're in China, your organization needs to know about that. I think the other thing is make sure you don't go in on the wrong visa. It can be tempting just to hop in as a tourist to do some business because it's quicker and cheaper. But again, if anything goes wrong, that is something that could have serious consequences down the line. And then, as you say, from an IT perspective, it's I think most larger organizations would expect you to leave your laptop, your work laptop, and possibly your work phone behind before traveling, before crossing the border. Again, that's, I think, to some degree up to the individual and the organization and their own risk assessment. But be aware, obviously, once you're there, that data is going to be difficult to access anyway, just because of the sort of the Chinese internet infrastructure which has been created, which is so different from the Western one. So bear that in mind as well. I think when crossing any border or any interaction with state authorities, if you're carrying IT hardware from your home country, it's undoubtedly subject to investigation.
Thanks, Tim. And I would just say, I think there's a heightened fear on both sides that are, in my opinion, blown out of proportion a little bit. Me and a colleague from our firm, we were in China last year. We visited Shanghai and Beijing with clients and law firms. There was no issue whatsoever. However, we did leave our laptops home when we traveled there. And it's really important to consider factors that could make the travel more like factors such as whether, like, why you're going either to China or from China to the US. Like, why are you going? Who are you visiting? What are the activities, business purposes that for your travel? What kind of projects you're working on? What is your business facing and dealing with in China? For instance, are there disputes with your vendors or customers in China? Are there potential investigations involving any of your vendors or your Chinese operations? Those are all key questions that need to be considered when deciding whether travel is safe for specific individuals of your company. And doing trainings like pre-travel trainings is very important to educate people on factors that may impact their travel and how to deal with different scenarios and what is your response plan in the event that certain less ideal scenarios do happen. I know we're short on time, so if anyone has more questions, please leave in the chat box. The last two pieces we want to discuss is that given the uncertainties between in trade between US and China, if there might be more reinforcement actions in China, whether it's data related or the past few days, China announced antitrust investigations into Google, even though Google has stopped its internet search engine services in China over a decade ago. There are now an enforcement action against a major US biotech company under the anti-foreign sanctions laws. So depending on what the US does in the trade space and otherwise involving China, there might be more countermeasures, whether substantial or symbolic from the China side. And the last, definitely not the least, is going back to the basics of doing due diligence and investigations, is what is the data that you need and how can you preserve, utilize, and potentially transfer the data out of China for your investigations or due diligence projects. So if you have the data, first and foremost, you need to understand your company's IT infrastructure and the capabilities applicable to China well before you need to do a specific investigation or due diligence project. Like regular business data should be fine to transfer, like trade-related, manufacturing, marketing activities, but then it can get complicated very fast depending on the types of data that need to be transferred. And if a third party in China has the data you need, like the audit or asking for supply chain related data, then You need to think whether all the factors are considered to put together a plan for obtain and use that data. And last piece I would say is the use of WeChat, which is widely used in China for business discussions, for file transfers, for monetary transactions, and oftentimes it's on people's personal WeChat or devices. So for investigations especially, do you have a policy on the use of WeChat and the plan for collecting and use those data? And if not, how can you persuade employees to turn over WeChat data for investigations? So there are ways to do it, like supervised collection, and you may also need to engage local counsel or forensic firm to assist with collecting, processing, and review the data. And the last piece is, are your investigators, compliance teams, or deal teams trained on all the requirements and considerations we've discussed today so that they know what to look out for when doing investigations and due diligence projects? So that concludes our session. I don't know if we have 2 minutes left. If anyone has any questions, please let us know. Otherwise, this is our contact information in case anyone would like to reach out if you have a question. Well, thank you very much to everyone for joining. Thank you, Patience and team, for your participating in this interesting discussion. We'll see you guys next time.